Grant bail at any stage at the later stage. So, denial of bail, the first trial of denial of bail, doesn't mean competency or bias or that the judge will never grant bail. Not proper for litigants to use decisions which are not in their favor to make false allegations of competence and bias. Where parties make decisions that are not in their favor, like it was the application for mandatory bail, the remedy and the procedure of challenging such decisions are provided for under the law. But not fair hide under allegations of competence. Accused person's father claimed that he made a complaint against the trial judge, the Judicial Service Commission, petitioning his removal from office. This, my view, that the said complaint brought in the Judicial Service Commission is not a bar of a stay proceedings or cannot be used for recusal. Whoever wants, otherwise, whoever wants to prevent a judicial officer from hearing a certain case would simply lodge a complaint with the Judicial Service Commission, which will cause uncertainty. Will not find any ground for refusal based on allegations of competence or bias. It should be noted that this court is a temple of justice, which upholds the constitutional principles of fair trial and natural justice as provided for under Article 28 of the Constitution. There is no way whatsoever this court can bypass the constitutional provisions and undermine the rights of accused persons to fair trial. This fair trial, indeed, as submitted by lawyers, is provided under the Constitution, and this court opposes to accord such a. I'll now go to issue number 3, which was raised by S3. S3 raised an issue of identity, that he is not the person mentioned in the indictment. That though they have the same course number and rank, the names and age are different. It is my view that this issue can be sorted out during scheduling incorporated and not at this stage of main applications. In the final result, this court makes the following orders. 1. Application of identity persons to transfer the file of ICD for lack of education is dismissed. Application for refusal based on competence and bias. The issue of identity for S3 will be sorted out during scheduling before printing. 4. I direct that this case, main case, be fixed for scheduling and
short adjournment before you give directions of today of 20 minutes. Consult with our clients to have a clear way forward in view of the ruling.
My Lord, in light of the ruling delivered a short while ago, we have been instructed by the accused persons to seek for reference to the Constitutional Court. My Lord, the instructions we have emanate out of that ruling and Article 28, Article 1, and Article 44, paragraph C. 28, Article 1, and Article 44, paragraph C of the Constitution. My Lord, the gist of this application is that in these proceedings, an issue requiring interpretation of Article 28, 1, 44C, 28, 1, and 44C has arisen. My Lord, in its ruling, the court considered that there is presently a complaint pending against it before the Judicial Service Commission, and concluded that the pendency of such a complaint is not a bar this this case proceeding, neither can it be used for recusal. My Lord, the grounds of that petition are for the Judicial Service Commission to determine they are not for determination here, but that complaint was made by A1 and A2. And is seeking the most severe outcome possible against a judicial officer. My Lord, it is seeking the removal of your Lordship. My Lord, in those circumstances, and regardless of the history of the committal proceedings, the applications, and so on, that your Lordship has observed or referred to, the question that remains, the answer, is whether this court can continue to be an independent and impartial court within the plain meaning of Article 28, of Article 1. My Lord, bearing in mind that that article cannot be derogated from, the question is whether in its plain meaning the court faced with the circumstances I have just described can be or even seen to be independent and impartial, particularly for purposes of trying those people who have lodged that complaint. My Lord, the place of the right to a fair hearing is a sacrosanct place. We hold it in the highest possible esteem. The only thing that stands between absolute tyranny, and the rights of an accused person. My Lord, there is a question we submit that has arisen in the context of Article 137, five of the Constitution. This court is required to submit to refer that question. Lord, permit me to read Article 137, 5. Lord, it provides that where any question, Article 137, 5, where any question as to the interpretation of this Constitution arises in any proceedings in a court of law other than a field court martial, court A may, if in its opinion, the question involves a substantial question of law, and B shall, if any party to the proceedings requests it to do so, refer the question to the Constitutional Court for a decision. My Lord, just for completion, when that referral is done, the Constitutional Court's guidance on the interpretation of the Constitution must be waited for, must be awaited before the matter proceeds. But, my Lord, under the two paragraphs that I have cited, paragraph A grants this court the discretion. Paragraph B does not grant such a discretion and is mandatory in its terms. My Lord, the way that article is framed, court in doing its work may find an issue and make a reference. But if any of the parties on whose behalf that work is being done asks it to refer. Our submission is that the court must refer. Essentially, what remains is the framing. My Lord, if the question is referred, and the Constitutional Court agrees that Article 28(1) would be contravened by proceeding in this matter, the disposal of the matter would be in accordance with that view. On the other hand, insisting to proceed with the matter in view of that question the Constitutional Court finds a violation, it means that the court is itself complicit in derogating from Article 28, 1 and 44. My Lord, I would, before I sit down, also propose the question. So that we can all be guided in this. So, my Lord, my proposal on the question rather long is whether my Lord, whether court presided over by a judicial officer against whom complaint by the accused person in that court seeking removal of that judicial officer from office under Article 144 under Article 144 of the Constitution is pending, where the complaint is pending, is an independent and impartial court an independent and impartial court in accordance with the plain and ordinary meaning in accordance with the plain and ordinary meaning. Article 28(1). Article 44(c), and is not a derogation therefrom. So the question captures the issue that has arisen and the reason why it is now necessary to interpret Article 28(1). (1) 44(c). My Lord, it's my humble prayer particularly in view of the mandatory text of Article 137(5)(b), that question as framed, as proposed, or an agreeable modification of the same be referred to the Constitutional Court. I so pray.
omusumba ye n'asaba n'agamba bagawugule gagende ewa Muluma 13 naye gavumenti lwakimukuganyira ku mutwe
era mbyagalira ddala pulezidenti wange
betwasaba bajje batusabire tebakoze eki tebalabise
tugenda kwekalakasa paka eza paka kulira